Executive compensation is complex. It's an important job for boards because one of a board's core fiduciary responsibilities is to hire and retain an effective chief executive officer. And you can't do that unless you really understand how compensation works, the different elements of compensation that presidents are looking for today, the ways in which your fellow institutions are compensating their presidents. And it's more than just a base salary. It may include things like a bonus, presidential housing, other perks and benefits, deferred compensation, tuition remission, sabbaticals, any number of things that go so far beyond just base salary that if you don't understand all the options that are available, if you don't ask those difficult questions and challenge those assumptions so that you know what's there, you're going to have a hard time doing an effective job of retaining that president. One of the real problems in the nonprofit world and certainly in higher ed is that if you don't do a good job with this, the world knows about it in relatively short order, particularly in our modern transparent world. And there's certainly a wrong way to do that, and that is to just have the board chair determine what your compensation is. Or a board chair in a small group of the board, not the compensation committee necessarily, making decisions in a vacuum or in secret, leaving the rest of the board out. That's a problem. That's a recipe for a front page news. What you want to do is have real engaged work by a committee, ideally a separate and discrete compensation committee, but it could be a function of an executive committee or another committee, looking at comparables, looking at other types of benefits that are being paid, looking at the achievement of the president, the results of that evaluation or that assessment to see what they're doing, and then determining in a very deliberative way, in a very inclusive way, in a very transparent way, what proper compensation and benefits would be. And then here's the key, and this is where the ball gets dropped sometimes, is sharing that information as a committee with the full board. Everybody on the board has a fiduciary responsibility with respect to what the president is paid, how he or she is compensated, what the employment agreement looks like. The heavy lifting might get done by a comp committee, but the full board has got to get engaged. If the full board is left out at some level, you've got ineffective governance at that organization. To our surprise, looking at relatively recent AGB survey data, most institutions do not have a discrete compensation committee. In publics, it's about 7%. In privates, it's about 18%. In institutionally related foundations, it's in the teens as well. The majority of organizations don't have a separate compensation committee for that purpose. The problem is then it gets crowded onto another committee's busy agenda or not included on the agenda at all, and now you've got an ineffective process. Frankly, there are many such examples, and they tend to make front page news in a newspaper or magazine. One that's very familiar is a case where a board chair essentially takes that decision onto their own shoulders. The board chair, in isolation, has a negotiation with the president, determines what that comp is going to be, maybe pulls in a couple of favored members of the board to help in that decision, but really excludes the rest of the board. Doesn't make a deliberative decision, doesn't consider comparables, doesn't go through what lawyers call the rebuttable presumption of reasonableness process, but instead makes a very unilateral decision. This is the comp, this is what we think it's going to be, and this is what it's going to be. Once again, that's a recipe for disaster. So a rebuttable presumption of reasonableness is a lawyer's term. It simply means that if you follow this particular process, you will have demonstrated that the compensation being paid to the president is reasonable. And then the burden shifts to a regulator, to a funder, to a member of the faculty or student to show that in fact it wasn't reasonable, and that's a hard burden to meet. So legally you achieve some compliance through that process of showing that you're determining that compensation is reasonable the right way. It's also a very good governance practice because here's what the process is. It's review and approval by an independent board or board committee. That means the president isn't deciding on his or own compensation. It means someone who directly reports to the president isn't making that decision either. It's really reviewed by an independent board and independent board committee. The second piece is that they're obtaining and relying upon objective evidence that the compensation is reasonable. What does that mean? Comparables. Apples to apples comparisons of similar institutions in similar geographic region, similar size of student body, endowment, Carnegie classification, you name it, but really peer-to-peer comparisons about what that compensation looks like. If you're looking at that and determine that you're in that mix, or if you're going to go higher on the scale, perhaps the 80th or 90th percentile, you've got good reasons for it, a very senior executive, particular accomplishments at the college or university, then you're going to be a long way towards showing that that's reasonable compensation. You have to rely upon it. You can't make a decision on data you didn't have when you made the decision. You have to have that evidence first and then make that decision. And then finally, simply record it in the corporate records of the organization, typically the minutes. If you go through those 3 steps, you've achieved that rebuttable presumption and you've kept your governing board in good shape.